Hello students, how are you? I hope you are fine. Today's topic is what's the difference between a judgment, an order and a decree under Civil Procedure Code. You see, under Civil Procedure Code, the decisions given by the court are divided into three categories. And what are those categories? These are a decree, second, an order or a judgment. So these are the three categories through which the court gives its decision in a civil case. Under section 2 clause 2, a decree is defined. Under section 2 clause 14, an order is defined. And under section 2 clause 9, a judgment is defined. First we will be doing decree. Under section 2 clause 2, decree is defined. It says it's a formal expression of adjudication by the judge. So already adjudication has been done by the judge in a judgment. The judgment has already been written by the judge. Judgment comes first, then comes the decree. It means decree follows the judgment. Judgment is in detail. Decree is in short form. Decree may be of 1 or 2 pages. Judgment may take 10 or 11 pages or more. In judgment, the judge actually decides the case in detail. So judgment is a document which is authored by the judge, and the judge narrates briefly or in detail the case of the parties. I am talking about judgment. So in judgment, the judge in detail or in a brief manner narrates the case of the parties in dispute and the points at which they were at issue, the points for determination, and the judge considers the evidence and the arguments of both the counsels. Then the judge makes a statement which finally decides the dispute between the parties. So finally the rights and the liabilities and even the remedies are decided by the judge or the court in a judgment. And of course, the grounds and reasons for reaching at that point. Why the court reaches at that point, why the court reaches at that decision is the reason and the grounds of that decision. The reasons and the grounds of that decision is given or written by the judge in a judgment, not in a decree. The decree does not contain any reasons or the grounds of the final decision by the court. Decree conclusively determines the rights of the parties. Already the judge adjudicates the matter in a judgment in a detailed manner, and after adducing the evidence, after putting his own views, the judgment may contain two things: operative dicta and ratio decidendi. Ratio decidendi means, here is ratio decidendi. So the part of the judgment containing the basis or reasons for the final decision is known as ratio decidendi. So it's a very vital part of the judgment and becomes a binding precedent for the future cases. So what's the reason for the judgment? What is the ground of the judgment? What is the reasons for the court to come to that decision? That reason has to be mentioned by the judge in a judgment, and that part of the judgment which contains the reasons for the final decision, it is known as ratio decidendi. And his personal views on the matter, are known as operative dicta, which is not a very relevant part of the judgment. The relevant part is ratio decidendi. So after a judgment is made, then follows a decree. The decree may be passed after few days. The decree may be passed after few days by the judge, or the judge may pass the decree immediately also after the judgment. Lately, the trend is that the judge, when writes the judgment, at the end of the judgment, the last para must contain that part which is similar to the decree, or it must contain the statement of the judge, concise statement of the judge, finally, conclusively, actually determining the issue between the parties. Because the judgment may contain many things. It may contain personal opinion of the judge. It may contain the parties' this evidence in detail. It may contain the arguments of the counsels of the plaintiff and defendant, and many more things. But the decree does not contain all these things. Even the reasons given by the judge for getting to that end point is given in the judgment. Even the grounds, even the case laws, even the precedents followed by the judge, that in detail is given in the judgment. But decree does not contain all these things. Decree is just a formal expression of the judgment. Judgment is in detail, and the judge have a leverage to write whatever he wants to write. He can apply his mind, he can read the case laws, he can read the precedents and apply the case law and precedents on that particular case, and then come to a final judgment. He has a leverage and he has a discretion to come at any decision what he likes. He may make a judgment in favor of the plaintiff, or he may make the judgment in favor of the defendant. That is what he wishes. But he should follow the law. If he is not following the law, then there are many remedies available to the plaintiff or the defendant. They can go for a revision if there is a procedural irregularity by the judge, or they can go for an appeal if there is any discrepancy in the judgment itself. If the law is not properly followed by the judge, or if he follows a wrong precedent or a wrong case law of a high court or Supreme Court, then appeal can be made by the affected party or the losing party. That's there. The remedy is there. But basically, what I'm here trying to say to you is the judgment is in detail, and it will contain everything whatever is needed to come to a rightful end to the case. So case is determined by the judge, and the that proceeding in a particular trial court comes to an end, and the rights of the parties are finally determined by the judge in a judgment. But what is the crux of the judgment? What is the main crux of the judgment? There must be some format. There is no format given in CPC for the judgment. The judge can write whatever he wants to write. He has a leverage about whatever he wants to write in a judgment. But there is a proper format for the judge to be follow. The judge should follow that format while writing a decree. Decree is in a very short form. It's the crux of the judgment. It's the summary of the judgment. It contains only the operative part of the judgment. Now, what is the operative part? Operative part is given at the end of the judgment, as I've already told you. At the end para, the end para of the judgment will contain the operative part, the final decision, actual decision, actual specifying the. For example, there is a suit of recovery. In a recovery suit, what actual amount has to be paid by the defendant to the plaintiff. For example, plaintiff have filed a suit of recovery against the defendant, and finally the judgment is in favor of the plaintiff. So what actual amount the defendant has to pay to plaintiff, that actual amount plus interest plus costs plus any other thing what the judge wants to write, that specifically is mentioned in the decree and nothing else. Obviously, after that, the seal of the judge, the sign of the judge, and all these formalities are to be completed. But the date of the decree will be the same as the date of the judgment. This is very important. The date of the decree will be the same as the date of the judgment. So decree may be of 1 or 2 pages only. It's just the operative part of the judgment. So it's a format given in Appendix D of the schedule of CPC, which you can see CPC Bare Act. At the end of it, a schedule is given in which Appendix A, B, C and D is given. You can see the Appendix D of CPC, in which various formats are given of the various type of decrees. So decree is a formality which is mandatory for a judge to observe. It's a formality, it's a formal expression of adjudication. I've already told you in this definition. So decree is a formality, it's a formal expression which the judge has to follow, and it is mandatory for him to follow that. In judgment writing, judge has a free hand. But in decree, he doesn't have a free hand. He has to follow proper format and that format is given in Appendix D of schedule of the CPC. So it's a formal expression of adjudication. Adjudication means the determination of the legal rights of the parties through proper reasoning by the court, by consideration of the evidence adduced by both the parties, and after consideration of the evidence adduced by both the parties and after hearing the arguments of both the parties, the judge comes to a logical conclusion. So this whole thing is known as adjudication, and that whole thing has to be written in judgment. But in this decree, it's just a formal expression of adjudication in which the court conclusively determines the rights of the parties and with respect to all the matters, disputed matters, or with respect to the controversy in the suit. So this is the main difference between judgment and a decree. Some of the important points you must remember is a decree must have been passed in a suit only. A decree cannot be passed in a petition or any application. Decree must be passed in a suit. And what is suit? Suit is that proceeding which is commenced or started by a plaint, drafting of a plaint. So first there should be a plaint by a plaintiff. When he files the plaint in the court, if the court accepts his plaint or if the court admits his plaint, that becomes a suit. So suit commences by the plaint. Now plaint is a different thing, and application and petition is a different thing. An application is just for demanding it's a request. A petition is a request to the court. If there is a, for example, violation of any constitutional right, if there is a violation of any legal right, you can file a petition. Petition can be filed to the government officers also. Petition can be filed to the administrative officers also. Petition can even be filed to the High Court and the Supreme Court. So petition and application is a different thing. It's just a request made. But plaint is a different thing. Plaint is something more than a petition. So the suit must commence by filing a plaint to the court. In some other video, I will be telling you in detail what is the difference between plaint and complaint and petition and this application. Here we must stick to the point. We are dealing with judgment and decree and order only. So I will be giving you some tips about these things afterwards. Now for this matter, so decree must have been passed in a suit. And what is suit? Suit is that proceeding in which a plaint is filed in a civil court, and when the court accepts that plaint, it becomes a suit. So it means a suit. In Hindi we say dawa. Dawa. So every suit is commenced by a plaint, and where there is no suit, there is no decree. So decree has to be passed in a suit only. It's very important for your preliminary exams. Decree contains names and address of plaintiff and defendant. Very important. The judgment may not contain the names and address of the plaintiff and defendant, but decree, which is a formal expression, it's a format is given, proper name of the plaintiff, proper name of the defendant, their address has to be written by the judge in a decree. If the subject matter in a suit is some landed property, then decree contains the description of that landed property. If there is any property, the subject matter of the dispute is some landed property, then a decree must contain that brief description of that landed property so that the parties may know what the real issue is. The decree must depict some map of that landed property. Then the other is what relief the court has given to any party. But the decree will not mention the reasons or grounds of the relief. That's the part of the judgment. So, what is the actual relief given by the court? That's very, very important part of the decree. So, what's the real relief? For example, it's a recovery suit. What actual amount has to be paid by the defendant to the plaintiff? What actual amount? 1 lakh, 2 lakh, 3 lakh, 4 lakh. What actual amount? Plus interest, 6% interest, 12% interest, 18% interest, plus costs all these things specifically has to be written by the judge in a decree, and the relief given by the court must be having some reasons. The court must be having some reasons or grounds to come to or to arrive at that relief. That reasons or grounds need not to be written in a decree. That reasons of relief, that grounds of relief has to be written by the judge in judgment, not in decree, because decree is just a formal expression of the adjudication given by the court with respect to the dispute of the parties, and that adjudication is already given in a judgment in detail. But formally there should be an expression of it, and that formal expression is just a decree, and it's just a very summary. It's a very summary way, 1 or 2 pages only. Have you understood the main difference between a judgment and a decree? I hope you have understood. So next point is, decree follows the judgment and should be in agreement of the judgment. Judgment comes first, then comes the decree. A decree should follow a judgment. Judgment should not follow a decree. Decree should be in agreement with the judgment. But as far as this legal value is concerned, judgment is having a more legal value as far as decree is concerned. Decree has to be in accordance with the judgment. For example, if decree is saying something else than the judgment is saying something else, but the decree is saying something else, then the decree has to be made again by the court. The decree has to be changed. The decree has to be changed, and it should be according to the judgment. Judgment cannot be changed. That's a different matter. A person can file an appeal against the judgment. That's a different matter. But a decree should be in similarity to the judgment. If there is any discrepancy between the decree and a judgment, the decree should be going, and a new decree had to be made according to the judgment. So a decree can be of 1 or 2 pages, but the judgment is in detail, as it contains the issues involved and mentioning of the case laws by the judge and the decision of the court with the detailed reasons. And these detailed reasons are not given in a decree. What are the kinds of decree? It can be a declaratory decree. It can be an executory decree. You see, declaratory decree is given under section 34 of Specific Relief Act. For example, declaration of title, declaration of status. There are many cases like this. Then the other is classes of decrees. Decrees may be divided into preliminary decree, final decree, partly preliminary and partly final decree. What is preliminary decree? For example, in partition suits, if a plaintiff files a partition, there are 4 brothers and they have a common landed property. Brother A files a partition suit, and the defendants here are B brother, C brother and D brother. In this partition suit, for example, the plaintiff claims 50% of property. The other brothers may be adjusting with themselves the other 50%. So 150% plaintiff claims, but the other 50% of the property, all the 3 brothers claim that 50%. Now, what are the shares of those brothers? So, actual determination of that question, actual declaration. So, this is known as preliminary decree. So, only declaration of the shares. If there is only, the court has, before actually granting the possession of the share, before actually determining what particular portion of the property has to be given to each brother, the court has to determine what is the actual share. Before giving them their share, actual share has to be determined. So only declaratory decree is given, and that declaratory decree is known as a preliminary decree, because in preliminary decree only declaration of the shares, only declaration of the rights of the brothers to their own shares is given. That A is allotted this share, B is allotted this share, and C is allotted this much share and D is allotted this much share. There is only declaration of their shares, and this is known as preliminary decree. Once their shares are declared, then the court give a final decree in which respective portions are actually allotted or given to those parties, and when that actual portion is given to the parties, that is known as final decree. Then there is partly preliminary and partly final. For example, if there is a case of case of a possession, plaintiff files a case of possession against B. So if the court grants the possession, that's known as preliminary decree. But if there is a question of this title, that can also be decided. You see, in a suit for possession of a property against a person, the plaintiff has to be showing some title to the property to the judge. Before the judge gives the possession of the property to the plaintiff, the judge has to decide first about the title of the property, whether the title of the property is also in the plaintiff's name. Because if plaintiff doesn't have a title to the property, how can he be given the possession, ultimate possession? So first the title of the property has to be determined. That is a partly preliminary decree. Then after title, the possession has to be given to. If the possession is also given to the defendant, that is also known as preliminary decree. You see, partly preliminary. But if there is an issue of mesne profits, mesne profits means, for example, the defendant had taken the illegal possession of the property of the plaintiff for many years, for 5 years, for example, 6 years. And for that 6 years, he had made some house on there, and he was taking rent. He was taking rent from that house. Actually, that rent was the right of the plaintiff. So, what was the rent which he had taken from that illegal construction? That has to be determined by the court, and that has to be given to the plaintiff. Now, at that point of time, the court has already issued a decree that is giving the possession of the property to the plaintiff and even determination of the title to the plaintiff. But at that point of time, mesne profits question has not been determined by the court. That question has to be determined by the court after looking into the whole evidence adduced by the parties. That can be done afterwards also. Is it clear? So that is known as partly preliminary and partly final decree. It's one and the same thing. Decree is the same, but it is partly preliminary and partly final. Final to the possession. It's final to the possession and title, but it's preliminary as far as mesne profits are concerned, because up till the point of the institution of the suit, mesne profits can be determined. But after filing of the suit, for example, if the case involves 4 or 5 months, it takes 4 or 5 months, or it takes one full year for the court for giving its decision. For that 1 year, extra rent is been taken by the defendant from this tenants. That extra amount has to be determined by the court afterwards. So afterwards, a new decree has to be made. So that is, for the time being, the mesne profits which are granted up till the point of the suit is given, and that decree is known as partly preliminary decree. Is it clear? Then I can give you a practical example of that. B has failed to pay back to A certain amount. For example, A has given amount to B and B has failed to pay back that amount to A. Now, A, that is plaintiff, can file a complaint against defendant, that is, it can file a suit. I should use the word suit against the defendant, that is, it's known as a recovery suit. Now, after hearing the arguments of both the parties, the court pronounced the judgment in favor of A. The court pronounced the judgment in favor of plaintiff A, who filed the suit for recovery against B. Now, in judgment, the judge would in detail give his reasons behind his decision. This part of the judgment containing the basis or reasons for the final decision is known as ratio decidendi, which I have already told you, and I need not to repeat it. And after the judgment is passed, the judge, after few days or after few moments, pass a decree, And you see, before writing the judgment, the court has to pronounce a judgment. After the judgment is pronounced by the court in open court, then the court has to write it. Then the court has to give it in a written form. There are at least 15 days for that. So after the judgment is passed, the judge after a few days passes a decree. So after the judgment is written by the court, then he can pass a decree. So I think it's not 15 days. After the pronouncement of judgment, there are few days. After some time, the court has to write the judgment also. Specifically, what time is given? It's in the CPC. It's not coming into my mind. So decree follows the judgment and should be in agreement with the judgment. So in this case, the decree is, in this case, for example, A has filed a suit against B, and it's a recovery suit, and the case is in favor of A. The court says that A is entitled to that amount. So if the amount is, for example, 70,000, so the decree will contain, judgment will contain, yes, that A is finally the recipient of that amount, and B should give that amount to A based on this and this evidence, based on this and this arguments, based on all the evidence and arguments and even the case laws. The judge comes to the decision that finally B has to give the amount to A based on this reasons and these grounds. Now that ground and reasons are not to be written in detail in decree. Decree only contain this matter. What matter? How much money B should pay to A? For example, 70,000. Exact recovery amount 70,000 plus any interest, 18% interest, 6% interest, any penalty, any damages if ordered by the court, plus signature of the judge, his seal of the court, and the date of passing of the judgment should be written in the decree. So this was a difference between a decree and a judgment. Thank you very much. So nice of you.